Good afternoon, everyone. Thanks for joining. This is going to be an exciting session today. I'm Justin Pierce, the co-chair of Venable's IP division. I'm here today with Shaheen Rothermel, who's co-chair of our firm's advertising law practice. Artificial intelligence, or AI, as everybody likes to call it, is fundamentally changing how companies innovate, create content, develop products, and engage with consumers. But as AI becomes embedded throughout businesses, and many of those that we work with, it raises a host of new legal questions and issues, many of which sit at the intersection of IP and advertising law, areas that Shaheen and I spend days in most of our professional careers working on. To help unpack this issue, she's going to join me in a discussion that kind of covers a good bit of what we think are some of the big categories that impact a lot of our clients, businesses, and organizations around the country. And just to make that short and succinct for everyone, I see that happening in three different areas. We're going to have a conversation today about some of the intellectual property and IP impacts of AI in marketing, some of the advertising and marketing compliance challenges that companies now face in the AI era. And then we'll go into some of the governance and real takeaways that in-house counsel and those responsible for compliance at brands should take away from this. Of course, if you have questions during this, feel free to ask us questions through the UI. We may not get to them all today. We're going to try to keep this very interactive. Just know that we'll listen to those questions, look at them, and get back to you. So looking forward to this. Shaheen, thanks for joining me.
Thanks so much, Justin, for having me and doing this with me. I'm super excited to be here because both Justin, you and I have had our own podcasts. I don't think we've been direct guests on each other's podcasts yet. And I know that this is a new format for our audience, for the Venable audience, vast IP and ad law groups. There's not going to be any slides. You can see that we're in a different environment, so we don't have slides. This isn't going to be the standard webinar. Not going to be CLE, so I want to make sure I tell everybody that right at the outset. But what I can guarantee is going to be a really great conversation. And Grace, would it be possible to adjust the screen so that we have the standard screen instead of what we're seeing right now? Thank you. But yeah, so really excited to talk about AI, the overlap with advertising and marketing. I think we're getting a ton of questions on our side, and we're seeing the overlap with the IP group. So you and I are doing a lot on the counseling side and much more increasingly on the regulatory investigations and class actions as well. The AI marketing issues are coming in ways that companies might not think about.
Right. So today, a couple things that we'll hit first, particularly on the IP side. I think one of the most commonly asked questions that we get and tasks that we often deal with those brands, with those organizations that are using AI in advertising comes in sort of the creation standpoint. When I talk about creation, let me back up. I'm actually talking about sort of the life cycle of creating ad or marketing, and IP is sort of uniquely situated where every IP asset, everything that you innovate and create, has kind of its own life cycle. So if you think of IP as starting at least with the conception of an idea, some creative work, there's always that point where it's an idea. It's not protectable as an idea, but as you put that pen to paper and create ad copy, as you draw a piece of artwork, those are kinds of content that then can be turned into copyrights. They're creative and can be registered. Over the life of that, let's say it becomes a product or a work of art, or in the advertising world, a really successful ad, that's the kind of thing that can be protected by registering it. You use it over a period of time, particularly if you build up a body of work over time, that's something that could even be licensed as part of its life. And eventually, as we'll even talk about today, depending on how well you manage that asset or IP right, you could lose it. You could have rights terminated. It could be committed to the public domain. So if you think about IP in that way, there's a life cycle to it that has different aspects that touch on the advertising and marketing cycle. With that, in the AI world, we hear a lot about the terms of inputs and prompts. Just about everybody who's listening to this, whether you've had a lot of experience with AI or a little, chances are you understand what a prompt is. But to be clear, I'm talking about the inputs, the instructions, the queries that you might put into an AI chatbot to get a response or to give it an instruction to do something. And that's whether we're talking about an AI chatbot or an AI agent that's modeled or built to accomplish a particular purpose for you. Generally, AI generated images are something that comes up all the time. With the advent of AI and how useful it can be for those who are in marketing and creative agencies, it goes without a doubt that AI tools are an awesome assistant, if you will, to help someone create works that may be used for marketing and advertisement. So it's not uncommon that companies and organizations have questions, or one of the first issues that they deal with from an IP side is, well, what happens with these AI generated images? And just a couple of words on that I'll bring up. One of the most important things to remember is that if you have imagery or an ad that's simply created and primarily created by AI, that's actually not protectable. Currently, under copyright law in the US, it requires human authorship. So something that's just generated by AI is not going to be protectable. Now, there's still use in creating these types of things. I've seen a number of companies make good use when it's governed and supervised to come up with maybe a first draft of a particular idea or vision that might be embodied in a prompt. But all of those companies, particularly those that are successful and operate with low risk, that's just a starting point. That output is not simply the result of a prompt that says, give me an image that looks like X, Y, or Z. That's often the first step in a long number of steps and even a workflow to get to a creative work that might be used in advertising. So with that, I've been talking a little bit about AI generated images and advertising from an IP bent. I want to take a step back from that and just get some thoughts here from Shaheen on a similar area about sort of what things do you see from your standpoint at that early stage when you're giving advice to advertisers and marketers?
Sure. And the big question I think that I get, and it's a misconception from a lot of marketers, is that when you're using AI, all of a sudden the rules that were in existence for 100 years, the FTC Act, just fall apart. And that's just incorrect. So I always start from the idea of there are definitely new issues, there are new problems and new solutions, but we are still looking at it under the same framework. We're looking at it under a question of deception, unfairness, whether something is misleading. And the same laws, for the most part, still apply. There are some disclosure laws that I know you and I have dealt with. We're defending some issues there. But yeah, so there are disclosure laws that we will talk about here. But when it ultimately comes down to using AI to create advertising, the real question is going to be whether or not the advertising that is used, that is conveyed by the AI output, whether it's an image, whether it's a claim, whether it's a full website, um, whether that's deceptive, whether that's unfair. Um, and the question for that then becomes whether or not the net impression, you conduct a net impression analysis of whether or not the net impression of the advertising within the context of the whole conveys a deceptive message. And that's what we always look at. You look at from front to end, the consumer experience. They might see this ad on the front end. They might see an image, AI created or not. They might see a consumer, what looks to be a consumer. Maybe it's a true consumer. Maybe it's an AI generated consumer quote that's not actually from a human being versus is.
Right.
Um, and they might encounter those touch points throughout that journey that even if some of the claims are true, even if some of the claims, we could substantiate certain parts of that. Once you start using AI created ads, you've got to be really careful that you haven't overcome this net impression into a way that it implies that that image of that person was a true person who used the product. The image of the person reflects what somebody can get using the product under typical circumstances pursuant to the FTC's endorsement guides. So that's really the first question, is the net impression analysis.
Right. That's interesting. And I enjoy hearing about the net impression. As an IP attorney. There's a number of standards that are used when it comes to consumer confusion, for instance. There's this likelihood of consumer standard, likelihood of confusion standard when it comes to trademark law. That's important. And a big part of the intent behind that standard is to try to protect consumers who might be confused between the source of a particular slogan or brand or something that operates as a sign of a product or its origin. Knowing that the law has these sort of overriding and overarching policy guidelines that it's always had, it's very interesting now to see how you have these age old standards and how they've kind of evolved to really protect the same thing. But we're now talking about it with the latest technology, AI, where it's rife for a lot of opportunities for all types of confusions, whether it's the net impression or if you think about how even consumers might now and into the future even find products, if before you look for a product or you're putting in a prompt or a search query, AI agents may be doing a lot more of that work of linking that search query up to a particular product. So the question on the trademark side might even be who's being confused. A human can be confused, but maybe an AI agent would not. AI agents in this aspect. There's a lot of interesting thought, leadership, and creativity going into what's happening with the ability to uh, modify AI algorithms or people who are very sophisticated in their ability to maybe change or access agents so that they read uh, instructions that maybe a human wouldn't see to serve you up answers or a product maybe that you didn't exactly ask for. But there are a lot of interesting games that you can be playing with AI agents these days that I think are going to open up this area for a lot of analysis.
I agree. And one thing I know, Justin, when we've been working on some of the projects, what clients are asking us on the overlap here, we talk about the human element of all of this.
Right.
And this human element and human intervention comes in a lot at various touch points of the analysis.
Right.
So when we were talking about the net impression analysis and the likelihood of confusion analysis, one thing I know that you said in the past is that it's a uniquely human issue, a uniquely human analysis, which I think is exactly right. Because a lot of times we see clients, companies, regulators say, okay, well, I just want to throw this ad or throw this website onto this AI, chat model and ask it, is this deceptive? Does this violate the law? And I see lawyers do this too. God bless them. Um, they'll say, does this violate the law? And then, AI is just fighting for its life out there trying to say, well, this is deceptive or that deceptive or this is or this isn't. But unfortunately, when it comes down to it, what a regulator or court's going to look at from the advertising side is whether the message in the advertising conveys a false or misleading net impression to quote the reasonable consumer. The reasonable consumer, at least not yet, is not an AI bot.
Right.
It's not an AI agent. It's a human being. And in some states, like Washington State, the statute actually says that the reasonable consumer is, quote, the least sophisticated consumer. I've made this joke before. I feel really bad for whoever that least sophisticated consumer in Washington State is, but but it's that's the analysis here. And so although we can use AI in that way as well, the human intervention and human element must remain at least for now.
Absolutely. And that's why I use that term that it's uniquely a number of these standards really do require human interaction if you think about it. If you think about sort of the policy and the basis behind them, and that the analysis one might go through, whether it's on the IP side where you're comparing whether there's some likelihood of confusion between two brands, when you're comparing what an average person walks away with as an impression from an ad, it tells you two things. It tells you on the front end that if you are a business owner or someone advertising, that it's a multi-factor analysis. This isn't something you should just be relying on AI to get you to the answer. This is something where hopefully you've got, if you're a small company or even a one-person company, that you've got the right knowledge and providers lined up. If you're a big company and you're under the pressure, like many of our clients are, to do things faster and do more of it, that you actually really have integrated your in-house counsel or people like ourselves to really take a look at what you're doing and your workflows to get to that end product. In this case, that end product being a marketing campaign, ad campaign, or something that might have visual elements, ad copy that all have some level of risk to them.
That's right. I think, the benefit of AI, or at least one of the benefits, is the scale. You can do
Right.
much more things at scale. You can do them faster. And marketing teams, as we both know, move at lightning pace. That's what advertising, because a lot of things move quickly online, on digital, on social, all of those things. So they sort of need to, and AI has created this wonderful tool for them to do that and
Right.
to make things more efficient. But with it, I hate being the lawyer in the room, but with it also comes the risks.
Right.
Because as soon as you start rushing, the more likely you are to make mistakes or overlook something that is a risk that if you had taken a beat, taken a breath, you would have noticed that. And we can talk about that in the we're talking about some of the governance questions here as well. But
Right.
one of the things that we're dealing with, I know, Justin, on one of the cases is in document production, when a regulator is coming to us and asking for documents about consumer survey data and the net impression analysis and A/B testing, conversion testing, essentially any testing you've done, company, about the net impression of your ads or what ads convert better or consumer perception, all of that. They're asking not only for those things generally, they don't want just an old school survey. They've started asking for things like search terms, from major searches, but now they're actually starting to ask, what were the prompts? What prompts did you, for anything that was created using AI, what were the prompts that were put in? Because when we go back to this idea of net impression and what's conveyed to the reasonable consumer, a company is responsible for substantiating all reasonable takeaways. And there might be more than one. There might be implied messages,
Right.
meaning if somebody, somebody who's a least sophisticated consumer might take something a more enhanced message away, but um, it's not just the message you intend to convey. It's any message, but the problem is the message you intend to convey is very explicit. If you've typed it into an AI engine and said, make an advertisement showing XYZ, make an advertisement showing a woman who looks 30 years younger after using our product, we're gonna have a hard time as their lawyers saying, "Oh no, that's not what they meant."
Sure. That'll walk into definitely an unsubstantiated claim territory.
Yeah.
Likewise, in terms of the kind of risk, your discussion there and what you kind of summarized in terms of being careful about what you put in terms of inputs. Likewise happens with IP considerations. Think about any of the creative things that you might upload in creating an ad. There's a lot of danger, to be quite honest, in having prompts that are discoverable, like you talked about, where you might say, hey, create an ad that looks like my competitors, or create an ad that looks like this great ad I saw on TV. And you have uploaded maybe imagery or examples of how that commercial looks, or imagery perhaps of an actor that plays a key role in that. You now expose yourself to perhaps copyright infringement. If you're talking product design, maybe design infringement, right of publicity issues, definitely multiple sort of creative IP issues. Okay. Thanks.
So yeah, I think that, and it's unfortunate too, because a lot of people ask about intent under a lot of these laws, and we can talk about intent, but it's the same standard. So just because you put something, in the AI, you're trying to get ideas, you're in the ideation phase, then the question, and maybe this is a question for you, but I'm just sort of pontificating right now, is sometimes I just put things in AI to just chat with it and think about, what about this? I was asking it about an auto renewal statute yesterday. I was having a real long conversation about this new idea we have about it. But in the IP side,
Right.
um, you know, that whole conversation, it's like, well, that might just be a tiny portion. It might be the same as a creative designer, in the shower on a run, having a thought that just goes by, and then you have this tiny portion, a minute, 1/100th or 200th of a part of the whole ideation phase.
Right.
And now you've introduced this IP consideration, right?
Right. You have in some ways, but I think if we're talking about maybe tiering the risk of these scenarios, that's a scenario where if you're doing some internal brainstorming, I think, and I think a lot of experts would probably agree, AI tools as they are now, certainly some of the leading frontier models are great tools for internal brainstorming. And if that's what you're doing and that's part of your job or task at that point where you're coming up with creative works and you are asking questions about what might look good, I've got this thought, I've got that thought, that's part of your workflow. And I'll back up. This is actually why you do want to have a governance plan that's not just in paper, but something that follows sort of the way you work and memorializes it. This is part of that brainstorming and conceptual phase that a lot of us go through, whether it's a small company or a large. That actually is fine. Where the problem starts is where you take maybe that first step where you say generate something that looks like X or Y, and then you leave it at that. That all of a sudden becomes the final draft instead of that being step one out of 100 different steps of you going through iterations, you going and adding and subtracting things, you going and brainstorming and working it up with a committee or a group of people to get it to a true finished product that has lower risk, but also has the added value that your whole company in that creative process or your team that you're working with can add.
It's a great point and a good segue. I think you and I, over the course of the past year or so, when we talk about AI, have used the word governance and a lot. I don't love the word because it's very highfalutin, but it's the right word, I think. Um, let's talk about that. What, in your opinion, does a governance policy look like, and what doesn't it look like?
Right. It's a good question. It can mean a lot of things. I think you're right. Governance can be overused because it's a very broad term that generally conveys a set of rules or guidelines, policy book that a person or organization should follow. That's just that broad. Now, the real key when you get to that, I think people should think about. You're going to hear governance in terms like that in the legal sense that that we're in. It can get overused. What it should really make you think next is what should I be doing to routinely and systematically reduce the risk in what I'm doing? How do I operate in a way that when we're talking about, for example, advertising and marketing, that we operate systemically in a way that gets us to ads that really resonate with our consumers, but at the same time don't present high risk repeatedly. There's a tension that all businesses have in there, and governance is a way to get there, and a way to sort of write down minimum guidelines that will keep you out of trouble, or certainly as a goal, ought to try to keep you out of the highest risk trouble. Whatever that is, reducing that to writing but making sure when you reduce that to writing, it actually fits with how you and your team work. That's the key to, I think, successful governance.
Absolutely. I think that's a really big point is that it's all well and good to have a piece of paper, but that document needs to reflect what's actually happening.
Right.
And if it doesn't, then when we're defending those actions, it's almost worse, right? Because you have a document saying, we know this is what we should have done to comply with whatever law we're now being sued under,
Right.
but we didn't actually do it.
Right.
So it's not a good look in the defense side. And it's also just as a practical matter, not particularly helpful. Why waste time on a governance document when it's not reflecting what you're actually doing?
That's absolutely right. One thing about governance, too, you definitely talked about in the sense of it can turn into sort of a gotcha document if it's sort of lofty and long and has all these things that you wouldn't realistically do. But to the extent that you have it and you're following it, think back to our earlier discussion about someone who is using an AI tool in the brainstorming process. That plus the fact that you have this history of doing that and a governance document that kind of shows that's actually part of your workflow, I think is the kind of thing that's probative of a organization. It's actually not trying to routinely infringe third party rights or not trying to infringe or violate FTC or state guidelines.
Absolutely. And it's there is intent in a lot of these laws where you look at civil penalties in particular will rely on intent. And so having a governance policy that you followed and that you slipped up on, then that can also reduce civil penalties. Putting aside, I mean, you might be able to get the whole investigation closed, which we have in the past in the affiliate marketing sense, because it's just, it's clear it was a mistake or it was a campaign that was a mistake and it wasn't anything done nefariously.
Right.
Yeah.
Right.
I think we might have some questions, but um, there's a question here. Okay, this is one we were going to get to about disclosures. Questions about what are the new AI laws with respect to disclosures. And I know this is something that, again, Justin and I, we've talked a
Right.
lot about
Right.
in um, all of its different permeations because disclosures, there's always a tension, right? You want to comply with any law requiring a disclosure. You want to make sure you're disclosing as needed, but you also don't want to make sure that you're, over disclosing in a way that it overwhelms the ad
Right.
that's being made. So I'll take a step back and say the disclosure laws themselves, we have one law that's well established in New York, the synthetic performer disclosure law, which essentially says that if you have a synthetic performer in advertising that was generated using AI, then you need to disclose the fact that it was generated using AI. The statute does not have specific terms that you need to use to disclose. It doesn't prescribe those terms. It also uses this funky language on synthetic performer. I've had some clients ask, does that mean a still image, or does that only mean somebody who is in action performing? Does it mean voice? And you know, I can answer this way. There's a common sense reading of it. Performer means somebody who's performing, but then there's other context clues in the statute that suggest that a court or the regulator would read it more broadly. And then there's obviously, I'm a lawyer, so I'm afraid of my own shadow when it comes to risk. I'm not actually, but as a lawyer, taking that risk approach would be to disclose if you're using AI. The new law that's coming out, and stay tuned, team, for a blog on this within this week or the next, is Hawaii. Hawaii has essentially the same requirement that you're using AI to generate images and advertising, then you're going to need to disclose that as well. And Justin, this is something that you and I have talked about. So I'd love your take on disclosures
Right.
and how you think a company can best disclose the use of AI, whether it's using, if you have IP or in the advertising sense. I'd love to get your take on that.
Yeah, no, it's a good question, a good topic overall. This is one of those areas where, from a governance standpoint, to use that word again, there's sort of AI aspects that are regulatory. You've talked about them from different states. I think you could probably argue that some of this is going to already become like emerging best practice standards. And then, if you think about it from a IP standpoint of using AI, oftentimes if you're using synthetic material or you're using AI to assist you in ad creative, it's actually a good best practice or something that we often recommend to track the provenance of what you're using in your advertisements. If you're tracking the provenance or tracking the origin of what actually went into it, was this image human created? Was this an original picture that our art director took of the landscape where our company's at for an advertisement? Or is this something that was synthetically generated from an AI model? You actually just need to know that fact. That's going to help you answer a few of these disclosure questions because you'll know to then put on some sort of watermark or label on your advertisement that says this was AI generated or synthetic media involved. At the same time, though, you'll know from a standpoint of what your creative team worked on if that was just a portion of what was created and a lot of work was done to refine that, maybe to make it look more realistic, match with your company colors, match to a specific niche audience. You may be in a position from an IP standpoint where you want to claim ownership for the artwork or for the creative aspect of that advertising. So you kind of deal with these two issues in one scenario with that.
That feels like a lot of tension, right? Because on the one hand, you want to use the AI to sort of help you, but on the other hand, you want to have ownership of it, and then you also have this disclosure obligation. And clients ask me this too, and it's always hard to answer this question as a lawyer, right? They'll ask, "Well, I know the law says I have to disclose,
Right.
but how is anybody going to know if I don't disclose? Because if I do disclose, I could be opening up to other issues like false advertising under the FTC endorsement guides, and I can talk about that. But essentially, the question of is, if I comply with the strict language of the statute, am I now opening myself up to unnecessary risk? Including, like, if I open myself up to that risk, I might eventually win that lawsuit, right? Those might be
Mm.
frivolous lawsuits, but we live in the US. My joke is always, today's Thursday. I could get sued in California for saying today is Thursday, and a court would let that proceed. So my point is that if you disclose, you're sort of waving this flag, and then you're opening yourself up to the plaintiff's bar out there to sue you on something else.
That's a tough tension. I think in many cases, because this is still an emerging area, there's not enough case law, not enough examples for us to really walk away at this particular point in time and say, hey, 60% of the time it's still better for you to disclose versus not. It's a work in progress. It's a bit of a moving target. I will say, in the sense of having been through IP disputes, IP litigation where discovery, particularly when it goes back to look at how was a IP asset created, having disclosed can be quite helpful, particularly if you're disclosing in the context that we talked about, where that company that's trying to defend itself actually does know what part of the creation process was artificial, what part was human. They did the best they could at that time, disclosed. But as part of that, and going through their homework and doing it systematically, knowing what was and what wasn't, puts them in, I would say, a much better position than those entities who have not done that.
Yeah, I think that makes sense. Like at the end of the day, I think it gives everybody a legal argument that you're giving consumers more information, and it gives you almost like this reputational argument that like, look, we're letting people go in with eyes wide open, and we're giving them full information. We're not hiding anything, and
Right.
and that's something that I always ask clients, and what's the downside? And there might very well be a downside, but I do like to ask that question.
Right.
One thing we had talked about earlier was about the governance, the policies, and the procedures. And you had mentioned one thing that you want to do is always tracking the origin or the provenance of the output.
Right.
One of the other things that you and I have talked about, and I know this is, I can't remember what the words you use are, but basically, I think it was having a human in the loop,
Right.
right?
Right.
That can you talk a little bit more about that? What your thoughts are about human intervention, human involvement in the governance program?
Right. Right. And think about it this way: having a human who can make a judgment, value judgment, to make sure some sort of output that comes out of what you are systematically doing in ad or marketing material creation, that point where you, as a marketer, working with your in-house counsel or outside counsel like us, make sure you have another step to where someone is looking at this and where someone is looking at the overall work of what you've created. And whether that's for, again, sort of the origin of the different inputs that went into the creative work, what was the at least your best guess as to the net impression you may walk away from. It's good to get the opinions of your counsel. Frankly, it's good, I think, in terms of risk management in general, but that can be part of having a human in the loop where there's actually a meaningful assessment and where that human can approve or disapprove of what's happening. Think of this in contrast to something that's fully automated, where in many cases, and many of us have, I've even worked with clients that are working on things like this, where they might have like a minimum set of guidelines. A particular product is then judged by that. It's all automated. It might score it on a risk model or something like that. That's certainly a way to do it, a creative way to try to get some level of internal prioritization. But no matter what, it's still at some point a executive from that group, probably in concert with someone from compliance or legal, has to look at it and make the final go or no go call. That's really what I mean by having a human in the loop and having a critical part of governance that's real and that isn't just a check the block move,
Mhm.
where I think many of us are going to be tempted to do that as the tools improve.
Absolutely. And you do have people who are stretched thin in the marketing, compliance, or in-house department where as you have AI that generates more advertising on scale, at scale, it's just the volume. It was already high volume. It now becomes, I think, overwhelming because a lot of companies online will test different things. They'll test
Right.
things all the way down to the placement of this text right above this text, using a green shirt versus a blue shirt on the model to see which performs better. And while those, I would argue, might be less material depending on what the text says, you might have AI that's doing some more, um, you know, drastic creation and
Right.
and more changes. So I think having a governance plan that really talks about the step by step from when the ad is created. A lot of times we have clients with ad, guidelines and marketing guidelines where it will be like, well, you can use this ad. This is a green ad. This
Right.
is a red ad. Never use this claim. And then these are the claims where you go to counsel. You
Right.
go to in-house counsel or the compliance department to confirm whether in that context it's okay.
Right.
And so the goal, I think, a lot of times is going to be having whatever tool you're using, whether it's AI, whether it's a combination of AIs or somebody else, making sure that output is, as easily, we're closer to the green and then to the extent you have new ideas or yellow ideas that you're taking those to in-house counsel judiciously or compliance department judiciously and making it as easy as possible for everybody to work together efficiently.
Right.
But at the end of the day, having a human in the loop or having an adult in the room will be critical because it's easy to forget that.
Right.
And you will only remember it once you get the subpoena, the complaint, the demand letter, the civil investigative demand. That's not the first time you want to realize that you had that oopsie moment.
Right. Right. There's one question here I see, and we're getting more questions coming in. Like I said, we'll try to get to a number of these. We may not get to them all, but we'll certainly be following back up with those of you who have questions that we have not gotten to. One that just caught my eye here is giving examples of when you can copyright or claim the IP on an AI image you generated versus when you cannot. So, on that issue, generally, I've got a few takeaways for you. I think if you have on one end of the spectrum a AI generated image, maybe after one prompt, sort of minimal questioning. And this is quite honestly where most people are at, where you put a prompt in and say, hey, create a picture that looks like XYZ. Almost all the time, that's something that you're not going to be able to claim copyright protection for. That's not human authorship. It doesn't get to the level of human authorship. And that's something the Copyright Office and so far under U.S. case law, it's been very clear that if it's primarily or solely generated by AI, there's no ability to claim human authorship, therefore, no copyright. On the other end of the spectrum, however, if you have, let's say, used the tool, I'll say more like a painter uses a palette and a paintbrush. And over time, you have uploaded different documents, you've given it particular guidance. You might come up with one version of an image. You then take it out of the AI and you put it into another software tool and maybe a graphic design tool. And you, let's say, you're coming up with a character to become the hero for your campaign and you say, hey, this is a little bit too cartoonish. I want to make this look a little bit more realistic, but artistic still. I have my own personal style I'm going to add to this. I'm going to make the eyebrows a little bit more bushy. I'm going to take the jacket they have off, and instead of it being blue like this, I'll make it green. You go through a number of iterations, move through different software as an example. This is just an example. But the more you put of your touches, your human spin on that, the more likely you're going to be able to claim copyright ownership. And then that brings up another thing. There was a question that talked about keeping prompts. This is the kind of situation where systematically you do want to have a process of subject to your document retention policies, but you want to work to keep track of these prompts. You want to work to keep track of the human authorship examples and iterative steps that you took as a creator. And when I say you, I'm talking about the collective you, maybe not just you, maybe your entire art or marketing department should be keeping track of what it's doing. Very similar to inventors with lab notebooks in yesteryear. Keep track of the steps of your idea, of the conception, what iterations you made. Remember what I talked about before with artwork or a copyrightable subject matter. It starts off as an idea. You've got to work that through and put your human authorship into it for it to approach the level of being something that you can get a copyright.
Absolutely. We've got another question. And I know there's some other topics that I wanted to talk to you about. So we'll get to as many of these questions, but there's a good one that's coming in. And one of the issues is when you have third party engines that use AI that are then describing an advertiser's product or service inaccurately or in a way that could be challenged as unsubstantiated by a regulator or class action plaintiff. Would the company be responsible for that inaccuracy? This is a fantastic question, one that is coming in a lot these days simply because the prevalence of these AI search engines. And here's what I will say. The output of the AI engine, and this is not something that we've taken a regulator to court on. So this is just us talking right now. But what I would say is that when you're looking at what the AI is providing as its output, as it's describing your product or service or your brand even,
Right.
Where is that language coming from? What is it looking back to? Because on the one hand, AI will often cite to something and it will have that citation in the answer. So you know what it's looking at, and it's possible that it's looking at a claim that reasonably conveys what the AI engine is then saying. In other words, that's going to be evidence that the net impression of your advertising is the answer that the AI engine generated. On the other hand, I don't know if we've used the word hallucination. Normally it's like a drinking game on an AI webinar. It's like, how many times can you say the word hallucination? But I think we've exercised restraint there,
Held
Justin.
off until
Yeah,
now.
we've held up. Um, but yeah, hallucination is a real thing. And so being careful and looking at the ad and looking at what the AI is saying about your ad and determining whether or not it is truly hallucinating. My recommendation for now would probably be, depending on what the circumstances are, in some cases, you might want to contact the entity that's creating that output. And most times, you're not going to be able to get any change. And therefore, what I would say is, as long as you are comfortable defending the position of the underlying sources, then you're going to have to live with what that entity is saying. And then we would have to go in as your counsel and defend you by saying that that is not your advertising. That is the advertising of a third party. It would be akin to Grace. I'm calling you out even though you're not on camera. Grace running around talking about your product based upon something she thinks about your product, and she's not getting any type of money from you for that. If, on the other hand, you as the advertiser are inducing the response, if you're paying for it the way we think about SEO, then we would be in a different scenario because you're essentially inducing a response. You've got a material connection to that. We have a harder time arguing that either it's not commercial speech or it's not your commercial speech, your advertising.
Right. It's an interesting conversation. It brings up another thought I have from an IP aspect, and I think it relates to a couple of the questions we received about what are some other things to watch out for in terms of risk management on an IP side. One thing that's really live, and since that it's something we're working on for different ad agencies and advertisers and brands now, is many advertisers and many companies, again, of all sizes, are now using all types of AI tools, not just some of the publicly available ones, but they're working with AI creative agencies. They're working with AI tool developers to come up with software or AI approaches to help ideate and come up with really engaging ads. In that contracting process, where you, the advertiser, are working with an AI tech company to do this, we ourselves have helped negotiate some of those arrangements or at least given advice to some of our clients who are advertisers and marketers. And one of the big things to do and to watch out for if you want to really reduce risk is to make sure you're getting some sort of indemnification provisions that give you indemnity or protection from third party IP infringement claims. You could be a advertiser who's got good intent, working hard not to infringe third parties. But as we all know, AI and software technology in general is not perfect. And when you have tools that have been trained on, let's say, safe material and unsafe, there's always a risk that some of your output that you could ask for might actually be infringing of a third party's design or copyrighted or branded material. So one way to reduce your risk right up front as a policy move here, I would regularly make sure any of your advertising tech, I'll call it that, in kind of a big category, contracts have been looked at by an attorney and make sure there's some strong indemnification from third party IP claims.
Absolutely. Contracting is something we could obviously do our own, a whole nother webinar about, and we might. I think we're seeing a lot of questions too, and I think this is giving us ideas for upcoming events. And not to go off on a tangent, but if anybody in the audience has any feedback on this format or other formats they would like to see, feel free to reach out to us with those and let us know what you'd like to see. There was one thing that we had talked about earlier that I wanted to go back to, Justin, and it was when we were talking about the net impression analysis and what is uniquely human. And I had a note to myself to talk to this audience about that, which is the use of AI, we as lawyers using AI to sort of throw the ads in there and say, are these ads compliant or are they not compliant? And then we're getting output that still needs human oversight. It still needs an adult in the room to look at it and take eyes on it. But what I'm seeing on the back end, where class action plaintiffs are challenging companies or regulators are challenging companies for their advertising, a lot of times what we'll do is we'll say, hey, look, you're going to have to prove that we had a deceptive net impression, that it was false. And you have to prove that that deceptive net impression was conveyed to the reasonable consumer. And you need to go out and get an expert who's going to do that. We have consumer perception survey data to do that.
Right.
And what I'm starting to see these plaintiffs' attorneys do is they're saying, well, look, that's not going to cost us that much because we're doing this to say, look, litigating this is going to cost a lot of money and you're not going to win. And their response is, nah, now with AI, it's actually not going to cost that much because I can just go out and have AI do the consumer perception net impression analysis. And I don't think that that will fly. I think that's something that they're probably going to start trying. They're very enterprising.
That's interesting. Hearing that, and look, there's something new every day that people will try. I think in that scenario, they'd probably walk right into a Daubert challenge. And what I mean by that, we've got a mixed audience, but a Daubert challenge, sort of said simply, it's a legal motion used to contest the admissibility of expert witness testimony in court. Based on that standard, it really requires testimony to be both relevant and reliable. And so when you make that kind of a challenge, the judge often will act as a gatekeeper in a sense to make sure that only scientifically valid evidence is presented to a jury. I think right now, given where AI stands, it's certainly getting better, but we still have a number of issues ranging from hallucinations to what is it trained on? Is this even the appropriate model to get the kind of information for standards and analyses that we talked about earlier are really, from a policy standpoint, still very uniquely human, and where the court and our legal society is very interested in what does that average consumer think? What is the net impression of that ad to a person who's buying that product in that state or jurisdiction? So, with those being the standards, I think you could challenge that approach. But it's interesting and certainly the kind of thing that with I think we're going to hear more of in just about every area.
Absolutely. And if a court lets it go through a Daubert motion, then my response would be what's good for the goose is good for the gander. And we're gonna do the same as the defense counsel. And if you're doing those surveys and you do it under the auspices of attorney work product, then there might be some protections there that you might not otherwise have if it's a closed loop system.
Right. Right.
So one thing that I wanted to talk about with you, Justin, was how you and I use AI
Right.
in our everyday reviews. I mean, Venable is, we like many law firms, I think Venable is doing a really good job at being at the forefront of using AI to both efficiently and in a sophisticated way give better work product, more efficient work product to our clients. Um, do you have any examples of like how you use AI in your reviews or what your associates or your group is doing?
Yes. So it's a good question. And actually, I'll start in the sense of you remember earlier, and probably many of you do, we talked about in this discussion with AI. I think a lot of marketing departments at the clients that we work with are becoming more and more inundated. They're getting more inputs, they're getting more things to look at, to opine on, they're getting more things to approve. And with faster timetables, more material, and not a whole lot of time to make decisions. So we use AI to help cut down that cycle. You combine sort of the speed that AI gives you with the judgment and knowledge and the analytical ability of our experienced groups and teams of attorneys. And that goes in every, let's say, practice group within the IP space. How is that relevant, particularly in this area? Let's say with something like advertising and marketing and the process of a workflow that a company might be using to approve ads. We're able to team up, for instance, with that marketing counsel or in-house advertising compliance person to help them increase speed, particularly for tough cases. Oftentimes companies, or again, if you're a one-person business or an expert who's a chief marketing officer at a big company, you've got a sense of what are the easy cases. You have a sense of what's the high risk. It's often those things that aren't sort of green, meaning go, or red, where you take the time. It's in the yellow, the area where there's, it could be one or it could be another. Those are the areas where we come in. We do a combination of things. We will use playbooks that we've created over decades of our experience in particular industries. use our ability to compare, for instance, that ad with what has flown in terms of being low risk and what has turned into be high risk. And oftentimes there's still a very case by case analysis. It's just that the AI and having comparators, for instance, loaded in a shared folder that the team has access to, makes us a lot faster and help surface what we would think is high risk versus low risk, and gives us an ability to then give that client really specific advice that's based on things that have happened within their particular industry or sector.
Absolutely. I think one of the misconceptions again that about law firms using AI, it's like either we get this question like, do you use AI or don't you use AI? And I would say everybody uses AI nowadays in some form or another. It's a question of how and and how you train it, right? If you go to a law firm like our advertising group or Venable's Autorenewal Solutions Team, Best,
Right.
if you come to us for advertising or auto renewal advice, you're not just coming to me or my colleagues, you're also coming to the group that we've created and the group that we've trained. And so we do the same thing with AI. We train the AI on our knowledge, and that knowledge is based upon decades. We did the first Rosca case with the FTC back in 2014. So our knowledge goes back really, really far. So what we have done is we've taken all of those cases, all of our advocacy, all of the cases we use to rely on for the advocacy, the cases where other companies lost, unfortunately, on some of the arguments, and we put those in, we put other reviews in, and that helps give us a baseline when we have a new client so that we don't have to just start from scratch and read everything. We sort of know what the biggest issues are, so we've trained the model for those biggest issues. We take what the client's given us, and it can give us really the red flags at the outset. And then to your point, I love what you said, because that's what we're doing too, which is you take the client's playbook. So this isn't just a one size fits all. You have different clients, you have different playbooks, you have different brand guidelines, and we've trained our models on those brand guidelines so that when a client, you have an overwhelmed compliance or in-house counsel department, they come to us and we're able to help streamline and do that as well. But I also go back and I admonish everybody, whether you're a lawyer, advertiser, lawyer at another law firm, um, make sure there's, to your point, a human in the loop, or as I say, an adult in the room, looking over it. Not all of this is automated. Maybe one day it will be, but right now we still are lawyers and we still have the duty to oversee what's going out.
That's right. I've got one more example I'll give you there in terms of how um, we and some of our teams work in this area. If you think about earlier, we talked about a situation where I think marketers, advertisers have to look at the agreements that they're actually negotiating with ad tech providers. In looking at those agreements, because we've looked at many over the years, we've come up with our own proprietary playbooks, our own checklists of what we pay attention to and what's high risk, what's lower risk, what would we advise a client to really pay attention to in agreement, what might be lower risk, so that we're not trying to boil the ocean or negotiate all 100 provisions in a 50-page agreement and focusing in on the top 3 or 4. That's something where our proprietary knowledge and experience actually is leveraged by having a playbook and set of standards that we will apply, that kind of use the types of guidance that we've given for years to give a client something that's, again, very specific, very targeted, and puts us at the ability to be able to give some of that type of advice faster than you otherwise would have not using those tools. So AI is like a really good, I think, augmentation tool for the legal practice as we've all used and known it.
Yeah. And it gives us the reasoning too for behind why we've chosen that advice, because it's always the why are we doing this question that we get that's completely valid, that we like to be able to answer quickly.
Right, right.
I know we're down to sort of the end, so why don't we give people a few takeaways, 3, 5 takeaways that in-house counsel or compliance can do to reduce their risk when they're using AI and with their IP.
Right. Well, I'll go back to what happens in the beginning when you're trying to create edgy, resonating, and earth-shattering ad or marketing campaign. Obviously, using AI is going to be part of it. Certainly in the brainstorming piece, you might come back to it between graphic design, But think about this. This is a case, and when I say case, a scenario that I see with a number of our clients who I think are doing a good job of this, where they're trying to satisfy a few things at once. Or they're worrying about, hey, how do we over time show that there's some human authorship and that we can protect the creativity in our ads, but also how do we do this stuff in a way that can move systematically fast and with low or moderate risk. So in a lot of those cases, you will see companies, and we advise them to do this. If you've created or maybe got to start brainstorming internally with the generative AI tool, it's very good to then take real world elements that you have approval to do, and whether that's agreements that have right of publicity considerations in them, where you have a release or license or permission from a real life actor to perhaps include that person in your ad. Maybe your art director, instead of just using the landscape as an example in an AI generated tool, takes a picture themselves of the landscape of where your company's at because it's beautiful, integrates that within the ad. Those are the types of things that, again, help you on human authorship, some creative defense around it. But also now you're at the point where, yes, you might disclose this was created using AI, but it's really AI assisted. And last but not least, you now have reduced your risk because you're using original creative or more human created assets, from the picture to some of the art modifications that you've made as a human. So you've reduced risk and you made something that's going to be more effective. That's a quick example of how to look at this, and something that you can take away and integrate what you're doing hopefully tomorrow.
Yeah, and from my end, I would just reiterate that AI, as of yet, has not fundamentally changed the standard rules of advertising, that you should still view your advertising in the way you had before, looking at the net impression, look at whether there's a deceptive or misleading impression that's conveyed, that you're not engaged in any unfair practices, whether or not AI was involved, ensuring that you are doing your best to comply with AI disclosure laws, that you're not using AI to circumvent some of the rules surrounding endorsements and testimonials if you're conveying somebody as a real consumer, that they are, in fact, a real user of your product or service. And again, just making sure that any outputs that you do have, that you are keeping an eye on them, that you have an adult, you have a human being looking at them. I suppose it doesn't need to be somebody of legal majority, but you have a human looking at them, and that you're looking at your prompts as well. I see we've gotten a lot of questions about the prompts, and I think we can talk about that maybe on another, maybe a soundbite or an article about the prompts, because I think that is something that we are going to start seeing a lot more in the lawsuits and investigations.
One last takeaway I'll give you in terms of just something to not launch with. Make sure, and this is something that's coming up, emerging, whether it's at the state law area, it's certainly something that's being contemplated in legislation that is not finalized yet. But everyone around the US is, whether they know the term or not, worried about what happens with their name, image, and likeness. So, to the extent that your content that's going to be in an ad deals with name, image, likeness, voice, even, I'd stay away from that unless you've got express approval to do that. That's one of the biggest red flags that will get you in sort of the square sights of liability at a state and maybe eventually even federal level. But that's something where globally it's an issue, and in just about every locality, whether it's actually the law or not, it's certainly high risk by just about every way you look at it.
Well, excellent. I think we're right out of time. This has been great. I love this, Justin.
Excellent. Great session. Thanks. This has been a good discussion. And thank you, everyone, for joining us today.
Thanks for joining us. Bye, everyone.